on this paradoxicity of the UK being more European than the EU, let's move with Mr. Iordanou, taking from where we were left with Mr. Paschalidis, how you understand Cyprus, what kind of business can we offer, financial services business, and where it comes to SELC, ACCA qualifications, where we stand, the ones are grandfather for the new ones, how you expect to, what kind of strategy you want to develop with the Accountants Association in the UK, who if you have always been very linked. And do you expect that we need new professional skills and tools to develop more from accountancy and auditors to accountants that can practice for investment funds and other activities further? Would the professional qualification be a lever for that? What are your thoughts on these questions? Yes, Kyriakos, you will need to unmute yourself.
Well, Eleni, it's been, I think, interesting so far what we've heard. I think Chris has made an excellent initial intervention, laying down many aspects of the agreement. From my side, I do have a number of, let's say, rhetorical questions that I will put forward in a while. Well, as far as the accountancy profession is concerned and the audit profession, we need to differentiate a couple of things. First, I agree with Leonidas, services are not properly addressed. I have, from my reading, I am not convinced that bilateral agreements can outrightly be done. So we may need to see how this joint partnership council will operate and what that means in essence. However, there is another aspect in the TCA that may slip our mind, and it is the fact that within the text of the agreement, unfortunately, Cyprus is earmarked, and there are a number of reservations, if I may call them like that, imposed on the free practice of the tax, accounting, and audit professions between UK and Cyprus and vice versa. So there is a big debate currently being going on for how the recognition of the professional qualifications will proceed. And anyway, whatever skills might be needed to touch upon the last question, to practice a profession, I would put them second in priority. The first and foremost of importance is the statutory directive, which describes the practice of the audit profession. In order to, let's just give me a couple of minutes to express a couple of questions I've got in a rhetorical manner, but I think the answer will be somewhere there. The primary question that we need to define, we need to ask is, what is UK today? Is the UK a third country? Is it a regular third country, or is it a third country with particularities? Because there are more than 100 third countries to the EU, but from what I know, there are just a couple with trade agreements, Canada, Singapore, and the UK. So it's not a normal third country. So I'm not pretty convinced that the rules that the EU rules regarding third countries do apply within the context of this agreement. That's why we've got some reservations about how easily we can recognize the UK professional qualifications, not only accounting, but all 38 of them that were struck off from the law L31 of 2008, which transposes the directive for recognition of professional qualifications into the Cyprus legislation. So it's a critical question. We need to answer that, because that could form the basis of everything else. I agree with Leonidas that there are three fundamental dates in 2020. The first one is the 24th of December, when we had the first, let's say, thought indication that there would be an agreement. Till that date, we had been working on the notion of a no deal, and we had been operating under the instructions by the EU and the notices issued to stakeholders of 2018. Those two relate to our profession. And from all discussions that were up and running at the time, nothing indicated that there will be an overall conclusion. The second date is the 26th, when we woke up in the morning, and instead of opening up Christmas presents, we open up a Word file with 1,200 pages. And of course, the 30th of December, where there was the signing of the agreement. An agreement which is still a draft one, and needs the approval and sanctioning of the European Parliament, which, as you very well know, has deferred its decision by 2 months for the time being. And in order to be effective, it has to be ratified by the European Parliament. So there is significant ambiguity and lack of certainty, both in legal and in practical terms. My second question, and which I put forward to myself, is, well, is the UK still in the single market? Do the rules of the single market apply as well? Because the single market encompasses a lot of rules, a lot of directives, a lot of other issues. I don't have a specific answer on that. And because we also see, that's why I'm referring that this agreement is it imposes particularities to the UK. We do see some more, let's say, extreme prohibitions on UK nationals in practicing professions in the EU. So it's something which is more onerous to the UK nationals. Concluding, I would say that the discussion around the professional qualifications, because I agree that the academic ones are, it's a much easier issue to tackle. I think there was a piece of legislation passed last year by our parliament, whereby they acknowledged and approved the British degrees, which I think it was the right decision to do. But for the professional qualifications, there are some serious issues, as I mentioned before. There is no automatic recognition. So far, we did what Chris described earlier through aptitude tests, adaptation periods, and other measures of recognizing professional qualifications. Actually, under the legislation, in a normal third country, it's up to the competent authority of the professional body to decide whether another qualification is equivalent to its own or not. And now we see that with the introduction of the Partnership Council, it is purported that we have an EU-wide recognition of the qualifications. I'm not sure about bilateral agreements, if they are allowed in the context that we read the agreement, because the agreement states two parties. The one party is the EU as a whole, and the other party is the UK. So I didn't see any allowance in bilateral agreements. And again, talking about bilateral agreements, at which stage? State with state, competent authority with competent authority, a professional body with another professional body. I'm not sure whether they are correct. And as far as the Article 44 mentioned before by Chris regarding the statutory audit directive, I believe that that article refers to already registered auditors in the EU and the UK, and their ability to move and work in other member states, not registration of new auditors post 1st of January of 2021, where there is a significant issue there. So what we have done as an institute, we have been liaising with the government, with the EU Commission, with the EU Parliament, representatives in Cyprus, with many ministries here, as well as the UK professional accountancy bodies, the two main ones, in order to find the optimum, let's say, arrangements going forward. However, everything was exploded on the 26th of December, where we had a specific piece of agreement before us that changed a bit the scenery. So we have approached all competent authorities and stakeholders in Cyprus, and we are awaiting for their response. If things were so crystal clear to identify and ascertain what the TCA intends, we would have received by now a clear response. Unfortunately, none of the 3 or 4 ministries that we approached the competent authority for the audit profession, which is the Cyprus Public Audit Oversight Board, the Commission and the Parliament, the European Parliament and our own Parliament, have come back with a definite answer. The Institute, ICPAC, has in place for more than 15 years now a joint examination scheme with ACCA, I need to mention that, which has been approved by the government since 2013. And we operate the scheme, and we think that it is well covered under the grandfathering arrangements. So there is a stream that would lead to membership with ICPAC through these professional examinations, which will be, of course, mapped with other third country, including the UK bodies, to see whether they are compatible and gladly recognize and approve the other qualifications. However, still we haven't received any formal, as I said, response how this recognition will happen. And just to sum up, just to close about the recognition, I go back again to the Partnership Council. Again, my reading says that well, it's partnership, then it means two parties to apply to the Partnership Council to recommend or approve whatever is put before it. So we need an institution from the EU and the UK body to apply together through a mechanism which I think will be soon available to everybody to easily understand it. And from then on, we'll see how things will go further. I still haven't cleared up my mind whether if a competent authority or a professional body applies together with a UK one, the Partnership Council, it obtains, let's say, a ratification approval, whether that UK body will automatically be recognized in any other member state. I think it would not be so straightforward. So concluding, I would say that more or less the TCA, I agree with Leonidas, is geared towards trade and businesses, rather than the services sector, which is left a bit lingering, I would say, and also constitutes a significant proportion of the business activity, both of the UK and both of the European Union. I think countries like Cyprus, who had been very closely linked with the UK's educational and professional system, have a longer way to go in order to find the fine-tuning that is required vis-a-vis other member states which had developed their own, let's put it like that, educational and professional systems. So that would be my intervention, Eleni, and I'm open to any discussion. I know I haven't provided any answer. However, again, I go back to my initial rhetorical question. What is the UK?
Thank you. My conclusions, there is to be the shorter, briefest conclusions I have ever given, because we coordinated, we agreed, we don't have the answers yet. And that it's all there, even about our ACCA scheme with the CELC of the 2013. So yes, let's go for some, yes, Laris. Mr. Vrahimis, dear professor, are you there with us?
Yes, I'm here with you.
Great. So what is more clear is that the lawyers keep their privilege, attorney privilege, in the UK Brexit agreement?
Sort of. I have a small presentation, just a short one. Let me just share it with you.
Great.
Okay. Let's just get it. Okay. Just get this started. So let's have a look at how things work with UK's lawyers now that they are out of the European Union. Now we have a profession that is controlled under Articles 2 and 11 of the Advocates' Law. One has to be a registered Cypriot lawyer to provide legal services, and legal services are defined in Article 2 of the Advocates' Law. They include, of course, appearance before any court on behalf of another person. They also include preparation or studying of court pleadings, that is, documents that are submitted as pleadings to the court. This does not include witness statements or expert reports. It includes giving legal opinions, so legal advisory services are also covered are also restricted only for registered lawyers. And then we have some specific work that can only be done by lawyers, drafting of documents submitted to the court in probate cases, registration of trademarks, registration of companies and ships, and similar activities. Regarding EU lawyers may provide legal services in Cyprus on a case-by-case basis. In so doing, they will be using their professional title of their member state of origin. However, if they are to appear in court, they have to appear along with a Cypriot lawyer. They can also set up a permanent basis in Cyprus under their professional title of the member state of origin. And again, in this situation, if they are to appear in court, they have to appear along with a Cypriot lawyer. However, after 3 years of providing services in Cyprus, they, on a permanent basis, they can be incorporated into the Cypriot legal profession, so they can apply to the Bar Council and be accepted as members of the Cypriot legal profession, and from then onwards they can provide services as Cypriot lawyers. Regarding third country lawyers, we have a provision in Article 7 of the Advocates Law, by which a third country lawyer, and that now includes UK lawyers, who are of a recognized standing, may appear before a court in a specific issue, in a specific case, provided they receive leave from the legal counsel. But again, in this case, they have to appear along with a Cypriot lawyer. They cannot appear alone. What happens now with the UK lawyers? Now, the matter is covered specifically by Article 549 of Title II, the Services and Investment part of the agreement, that's serving 549. Now, a UK lawyer may supply legal Cyprus legal services and services relating to legal arbitration, conciliation, and mediation services, provided, but this is limited only to matters relating to UK law and international law, excluding EU law. So they can only provide services in legal advisory relating to UK law and international law, excluding EU law, and also in matters relating to legal arbitration, conciliation, and mediation services. However, this is limited to matters where the dispute relates to the interpretation of law. They cannot act as arbitrators, conciliators, or mediators, and they they are not allowed to appear in arbitration, conciliation, and mediation services to provide such services in disputes that do not involve the application and interpretation of law. And finally, regarding the educational qualifications, until 2020, it was specifically provided in our law that a person that has a law degree from a UK university could be registered in Cyprus as a trainee lawyer. Now, this change in 2020, the new provision is that to be registered as a trainee lawyer, an applicant must possess, among others, a law degree from a third country university, as the legal counsel may from time to time recognize. So from now on, the degree has to be recognized by the legal counsel. However, what we expect is that any UK LLB degree will continue to be recognized as before, to the extent that this degree is accepted by the Law Society and the Bar Council as an undergraduate law degree. So this is my presentation. Thank you very much.
Thank you, Larry. So if I understand well, we do not expect the bar to have a position different from the one of the Law Society when it comes to accept and recognize a UK LLB.
Especially an LLB degree will be accepted in Cyprus.
Great.